What were you doing with meth? I don't know how they missed that at the jail, but they say it was found when they were doing cell checks at the jail and that you were attempting to flush something down the toilet. 2024 CR 1707, State of Texas versus Regina Weaver. Can I have parties announced for the record for the state?
Daniel Escobar from the state of Texas.
Defense.
Eddie Bravanek for Miss Weaver.
And are you Miss Weaver?
Yes.
I'm sorry, you're going to need to put your purse down on one of the tables. Counsel, have you received all the discovery? Did you review it with your client?
I did.
Court will find that the state is in compliance with discovery. Ms. Weaver, did you review the document entitled Application for Community Supervision or Deferred Adjudication with your attorney?
Yes.
Did you understand it and sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
Judge, we're waiving the repeat offender enhancement allegation. And in addition, Judge, just to put on the record, defense did ask about possible surveillance video from inside the Bexar County Jail on this case. I had emailed out to the detective, forwarded on my request to someone at the Bexar County Jail. So far, we haven't gotten word of it, but I did inform the defense about that. But we decided to again make this offer, reach this agreement despite that.
Right, defense.
Right away, this case takes an interesting turn. The defense is admitting there's potentially missing jail surveillance footage, but they're still moving forward with a plea deal. That's a calculated legal decision.
Do you wish to proceed without that discovery if it exists?
We do. I went over the issue thoroughly with Miss Weaver, and honestly, I got her slightly better deal because of the issues with the discovery. And I went over it and said, look, if you truly didn't do this, we should wait for the video. In spite of that advice, Ms. Weaver chose to go forward. So it did help her, although there was that out-ascending discovery issue. So I went over each and every issue on the case, and she was satisfied that she still wanted to go forward.
All right. And state, other than waiving the repeat offender enhancement allegation, are you proceeding on the indictment as presented?
Yes, Judge.
Any objection to the state's waiver?
No.
All right, Ms. Weaver, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Did you understand you're charged by indictment with possession of a controlled substance, penalty group 1, 4 grams to 200 grams? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? You need to speak up.
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Ms. Weaver will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, there's a $500 fine. State recommends deferred adjudication. They're taking in consideration 2024 CR 2832, and they're asking for a referral to felony drug court. Did you understand that should be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
There have not.
Outside the agreement, the state is requesting that your community supervision be for a term of 3 years, that there be a TAP evaluation and 120 hours of community service restitution. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No.
State any evidence.
State officer states exhibit one and all attachments.
No objections.
All right, did you review, state you may be excused. Did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are we proceeding with sentencing?
If the court would allow us, yes.
Anything you wish to say on behalf of your client?
No, Your Honor.
All right. So I have a few questions. So do you have any children?
Yes, ma'am.
What are their ages?
21, 14, 9, 8, and 7.
All right. And where are they? Who do they live with?
My 14-year-old lives with me. My 21-year-old is out of the house, and I share custody with the younger 3.
If you're drug tested today, what are the results going to be? And you're going to get drug tested. Here's the thing, you need to be honest with me.
Yes, ma'am. The medication that I take, I don't know how it comes up on the test, but I do take medications
For what?
for anxiety and depression.
I'm sorry, what?
Anxiety and depression.
This is where courtroom sentencing often shifts from paperwork to reality. The judge isn't just checking boxes anymore, she's testing credibility. Notice how quickly the conversation moves from prescribed medication to methamphetamine.
And so what were you doing with meth? I don't know how they missed that at the jail, but they say it was found when they were doing cell checks at the jail, and that you were attempting to flush something down the toilet.
I had just come back from the hospital having an x-ray done, and it was found in the cell with me. There was nothing found on me. It was in the cell, and I'm not too sure.
Well, I think what her real question is, you've used meth, right?
Yes.
All right.
Yeah, because it's saying that it was found inside her bra.
Yes, I think it stated that it was being flushed down the toilet and that it was found inside a bra. I think she's I don't know. I mean, she may say differently. I think her concern is the drugs, right? Using drugs. And she wants to tell you to tell her.
Yes. Yeah, that's what I'm trying to
Yes.
understand, because what I'm reading, the stipulations that you stipulated to, it says detention staff were conducting cell checks and they noticed you attempting to flush something down the toilet. Detention guard Garcia then requested for additional help in restraining you and retrieving E2. I was then advised the detention staff then conducted a strip search of everyone in the cell and located E1 inside AP1's bra. I was then advised that AP told the detention guards that E2 was located inside her underwear. So they're saying that you told them it was located in your underwear, both locations which would constitute a strip search. So they're saying they found it in the underwear and the bra.
So
And then
Judge,
what?
if I may, I'm sorry, and I had trouble with this first. When they said underwear and she admitted to underwear,
Mhm.
I don't think they ever found it in her, her panties. But some people, when they say underwear, they mean bra and panties or underwear. And some people, it's like your panties. So when she said underwear, I think she was referring to her bra, I don't think anyone is saying that they found it in her panties area.
Well, I'm reading
This may sound like an argument over tiny details, but legally it isn't. The defense is trying to clarify exactly where the drugs were allegedly found, while the judge focuses on something much bigger, whether they were hidden on her person at all.
what I'm reading from the police report is that they're saying bra and underwear, and they said both locations.
Yeah, so Judge, I literally, I don't think it says they found it in both. I think she says I admitted it with underwear. And I don't mean to make a mountain on a molehill, but I think when she says she admitted it was in her underwear, she means she's admitting that it's in her bra. And I don't think that the state would say, nor does anyone saying that
So
they,
here's the thing, that what I'm reading in the report, whether it's underwear or bra, it's on her.
yes.
And it's not something from the hospital because they're saying it was in clear bagging. Unless the hospital has started putting their medications in clear baggies.
No, ma'am. It was in a wrapper for a sanitary napkin.
Okay.
And it was in the cell with me. I do have an issue with I used previously, but since then I've stopped using and attempted to get things back on track.
Okay. So are you employed?
No, ma'am, not currently. I was on full house arrest
All right.
for a restaurant for a while, and then for the past, I want to say, a year or so, I haven't.
Speak up, ma'am.
Yes, for the past year or so, I haven't been employed just because I was trying to. I actually lived in Louisville, and then I moved back here to San Antonio. While I was moving, was when this incident occurred.
All right. Who lives with you with your children?
Myself and my grandfather.
Despite everything you've heard, notice what happens next. Instead of sending her directly to prison, the judge chooses deferred adjudication with strict supervision and drug court.
All right. This is what the court is going to do. The court is going to sentence you to 4 years deferred adjudication. There's going to be a referral to felony drug court. She can do that out of custody. Do not miss that appointment. Do you understand?
Yes, ma'am.
And there'll be a TAP evaluation out of custody. Follow recommendations. And you need to let felony drug court know about your drug history and your drug issues. You understand?
Yes, ma'am.
There's a $500 fine that will be probated. I'm going to order the UA hotline until further notice. And we're going to have you do a drug test today. No later than 3 p.m.
Yes, ma'am.
And they'll give you the location.
Yes, ma'am.
There's to be regular reporting by Zoom or in person. Proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. There's going to be 90 sober meetings in 90 days. Field visits 1 time per month until in treatment. There's to be 200 hours restitution. I'm going to order parenting classes. Once you complete the parenting classes, the community service hours will be deemed satisfied. There's to be no unsupervised contact with minors. Once you've started parenting classes, your counsel can approach me about that, and I'll consider changing that. Take in consideration 2024 CR 2832.
JJ, I'm sorry, may I ask a question?
Yes.
I'm sorry, when you say no unsupervised contact, you mean minors besides her children? Because
Children, period. So she says she lives with her grandfather, so I'm assuming her grandfather is there.
but I think her testimony is her 14-year-old is currently with her.
Yes.
I don't know what we do with a 14-year-old.
Yeah.
So my concern, if the court says no unsupervised contact, so the grandfather is sufficient to satisfy. All right. I'm just making sure I don't set her up for failure.
All right, thank you.
Thank you.
Take in consideration 2024 CR 2832. And there's to be restitution, if any, to the Bexar County Laboratory for drug testing. Probation, is there anything else she needs? Is there anything else you need from the court to be successful? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes.
And did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
We can go off the record, and this court, to be successful on probation, communication is key. If you have an issue, let probation know. If you feel as though they're not addressing it, you can always come back to the court. Do you understand?
Yes, ma'am.
All right, good luck to you.
there.
CR 2517, State of Texas versus Humberto Chavez. Can I have parties announced for the record for the state?
Jason Gearhan, Your Honor.
Defense?
Adrian Pettis.
And are you Mr. Chavez?
And Your Honor.
All right, I'm showing you what's entitled motion to revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor, I did.
Are you the same Humberto Chavez who was placed on community supervision in 2022, CR 2517, for the offense of possession of a controlled substance, penalty group 1 less than? All right, does anyone want to make a oral motion to the motion to revoke?
Yes, Your Honor, oral motion to change the verbiage. States possession of controlled substance penalty group 1 less than 1. It says group, we're asking for less than 1 gram. No objections.
All right. So are you the same? All right. Are you the same Humberto Chavez who was placed on community supervision in 2022, CR 2517, for the offense of possession of a controlled substance, penalty group 1, less than 1 gram, on June 6, 2023, for a term of 3 years? Is that you?
Yes, Your Honor, it is.
All right, state.
Yes, Your Honor. Violated condition number 1 on or about the 25th day of August 2023 in Bexar County, Texas. The defendant, Humberto Chavez, committed the offense of evade, arrest, or detention in violation of condition number 1.
How do you plead to that? True or not true?
True, Your Honor. Your Honor, we'll waive the remaining violated conditions.
Any objections?
No, Your Honor.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, and sentence you up to 2 years in the state jail facility and up to $1,000 fine?
I understand, Your Honor.
I'm sorry, everyone, just one moment. Can you mute us, please? All right, so did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, sentence you up to 2 years in the state jail facility and up to $1,000 fine?
I understand, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, Your Honor.
Court will find violation of condition number 1 true. Is there an agreement?
There is, Your Honor.
And what is the agreement?
The agreement is to adjudicate guilt, to revoke the individual office probation, sentence him to 180 days in the Bexar County, I'm sorry, not the Bexar County, the state jail facility. And also the state will take into consideration the 2 new number 1s, clause numbers 715.
Everyone, please whisper.
715-748 and 715-749. Your Honor.
All right, is that the agreement?
Yes, Your Honor.
Mr. Chavez, are you asking the court to follow that agreement?
I am, Your Honor.
Are you waiving your right to appeal?
I am, Your Honor.
All right, the court will follow your agreement, sentence you to 1 year in the state jail facility, give you credit for any time served, take in consideration 715-748 and 715-749.
Your Honor, our agreement was for 180 days.
Oh, I'm so sorry.
That is.
Yeah, I was just seeing if people were paying attention. All right, I'll follow your agreement to 180 days in the state jail facility. Mr. Chavez, you do have, it appears that you have a drug or alcohol problem. If you would like, I could refer you to the therapeutic community. Whether they place you in the program or not is completely up to them. I don't have any jurisdiction over that. However, if you were placed in the therapeutic community, it will not extend your 180 days. So would you prefer that or no?
No, Your Honor, actually, I'd like to just be done with.
All right. So here's the thing. If you don't get your life together, you're going to be back right here with another drug case. Do you understand?
I understand, Your Honor.
All right. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
I did, Your Honor.
All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
I do, Your Honor.
All right, we can go off the record. Mr. Chavez, I remember you, and I will tell you what is happening with your face. That has gotten bigger than it was the last time you were here. You need to go see a doctor and have that looked at.